Yes, would you ask Mr. Maddison to come back in, please? Thank you. Right, Mr. Maddison, are you ready to carry on?
Yes.
Thank you very much. Yes, Mr. Millett.
Mr. Chairman, thank you. Mr. Maddison, I'd like just to, before I go back to the flow we were in before the lunch break, just to explore one thing with you that we're not quite clear about. Can I ask you to look, please, at Mr. Bosman's witness statement to the inquiry, which is at TMO 00880562. I'll show you the first page of that. There it is. And if we go to page 3, please, can we go to paragraph 12? And in paragraph 12, he says, I've been asked to set out a summary of my roles and responsibilities while working for TMO up to the date of the Grenfell Tower fire on 14th June 2017. The set of contracts management, I was responsible for the development and implementation of strategic vision to deliver service contracts, compliancy, responsive repairs, and M&E capital works to the 10,000 homes managed by the TMO across the borough. In respect of responsive repairs, particularly, that he refers to there, who was Mr. Bosman's line manager?
Well, I was Alex's line manager. In respect of responsive repairs, he was responsible for responsive repairs to mechanical and electrical contracts that he managed. So that was the gas, electrical, and the M&E piece.
Right. So when he refers there to responsive repairs, I mean, it looks as if he's referring to responsive repairs across the piece, unqualified. Do you say that's wrong?
That's wrong in the sense of, so at the outset of Alex's employment, he had a client role within for the internal client, for the internal repairs direct contractor, and there was a team. But that team transferred into Repairs Direct and reported into Graham Webb, who reported into the executive team.
Right. Who was responsible, if not Alex Bosman, for responsive repairs that were not M&E connected?
Graham Webb.
Now, Graham Webb, as I understand it, joined the TMO, is this right, in 2015?
I don't know the date he had joined.
He wasn't there when you started, was he?
No.
So who was responsible for non-M&E responsive repairs from 2013?
There were two people, Paul Javot and Andy, can't remember his name. There were some, so they were the heads of Repairs Direct at that time.
Right. Wasn't Paul Javot part of Repairs Direct?
Yes. So he was the managing director of Repairs Direct, or an interim acting managing director.
So forgive me, but help me with this. Who at the TMO was responsible for non-M&E responsive repairs?
The managing director of Repairs Direct, who would report into the executive team.
I see. So you're saying that Alex Bosman's responsive repairs role related only to M&E and not to non-M&E, and the non-M&E was Repairs Direct themselves.
So there was a period when Alex Bosman, in his role, had a client role for Repairs Direct, but it wasn't a managerial role. It was very much about the client scrutiny. But that team transferred into Repairs Direct and all reported into Graham Webb when Graham was there, or probably before, when Paul Javot was in post.
Right. So Repairs Direct was essentially the TMO body, is this right? The internal TMO body responsible for responsive repairs that are not or were not M&E related. Is that how it worked?
Yes.
I follow. Now, let's just, pursuing that a bit further, look at a document. Can we go, please, to TMO 1 0009447? And I'd like to show you the first page of that, first of all. This is a minute of the operational health and safety meeting held on the 12th of May 2015, and we can see that you were present, as was Alex Bosman. And if you look, please, at page 5, I'd like to show you paragraph 5.3. This is under FRA stats 8th May. And under 5.3, it says JW to send PM, that's Janice Ray to send you, a schedule of the responsive actions, and PM to pick up with Paul Javot. That's the same Paul Javot that you referred to, isn't it, a minute ago? And he's of Repairs Direct, wasn't he?
Yes.
Yes. So can you tell us why that particular question, schedule of responsive actions, to be picked up between you and Paul Javot, was your responsibility?
I can't remember at that time, but I suppose in some cases there would be a discussion to be had about which team was responsible, and so maybe it was around something like that.
Right. Did you become responsible for the non-M&E Repairs Direct governed responsive repairs?
No.
So can you explain why you are getting involved in picking up a schedule of responsive actions with Paul Javot of Repairs Direct?
I'm assuming that there may have been some issue where there was a judgment as to which team was going to deal with some of these issues, and so maybe it was something like that. I don't recall the conversation, but at a point, my team, Alex Bosman, had a client role, but it wasn't a managerial role over Repairs Direct. Right. Paul Javot was an interim, and then when and I think at the time when Paul was there, that's when the client role went into, the client team rather, went into Repairs Direct as a whole, and reported into Sasha Jevons and Barbara Matthews.
Right. Did you discuss the schedule of responsive repairs with Paul Javot?
I can't remember what that discussion was about.
Did you discuss overdue repairs with him at all? Or anybody else from Repairs Direct?
I can't remember what the discussion was about.
Right. Well, let me just see if I can prompt your memory. Can we go, please, to your diary from 2015, TMO 008797776, page 38. And if you go to if you go to the second page on that, you can see that this is May 2015. If you go to the top right-hand corner, you see you see there's some writing up there, first of all, can you confirm that these are notes that you made of the operational meeting on Monday, the 18th of May?
I don't know what they relate to, but it may be those.
Right. And at the very top, you can see the name Paul Javot. Is that right?
Yes.
Yes. And then there's a little arrow which points up, and it says, and again, correct me if I'm misreading your handwriting, it says overdue responsive repairs, FRAs. Is that right?
Yes.
And then something underneath it, FRA, is it voids or volumes?
Works.
Works. Costs stroke process. Does this prompt your recollection about having a discussion with Paul Javot in May 2015 about overdue responsive repairs for the purposes of FRAs?
It doesn't prompt my memory now, but it looks like the primary reason for the meeting was to talk about FRA works, right, the costs of those works in the process. So maybe there was an issue about moving budgets from one place to another, or how we would. I can't remember exactly what the issue was at that time.
You can't help. Right. It looks from the document, though, that you, at least at this stage, got involved with Paul Javot on the subject of overdue responsive repairs for the purposes of FRAs. Is that a fair way of reading the document?
It looks like I've had a conversation with him about that.
You can't recall it?
No.
Right. Let's then go back to where we had left off before the lunch break. Can we go to TMO 008698184? This is a chain of email correspondence in October 2015. And I'd like to start on page 6, please, of that email run. This is an email from Janice Ray to Rebecca Burton of the LFB on the 22nd of October 2015 in respect of further potential deficiency notices for fire-rated flat front doors, which were missing self-closers. I'm summarising the topic. Just before I show you the chain, just to remind you of the chronology, do you remember that a deficiency notice had been issued by the LFB in respect of Adair Tower on the 12th of October 2015, only 19 days before a fire there on the 31st of October 2015?
I don't think I was aware of that.
Right. Let's go to page 3, where we see Rebecca Burton sending an email to Janice Ray on the 4th of November 2015, so after the Adair fire. Towards the bottom of page 3, she says, "Hi, Janice. Tried to call, believe you're in a meeting. Just wanted to touch base regarding the fire at Adair Tower, as I've been on leave and I'm currently pulling all the pieces together. I do have some questions that I need to feed into my post-fire review report that I'm hoping you can help me with. They will also feed into our meeting next week." And then over the page, she asks a series of questions with bullet points. And in the last 2 bullet points, she says, or she asks these questions: what is the current status regarding FRAs undertaken for your estate and reviews undertaken? Do you have a rolling programme that is completed by Carl on an ongoing basis? What systems are in place to act on significant findings identified by the FRAs? You see that?
Yes.
So those are the questions. Now, just to show you the email chain itself, the top of the email chain, if you go to page 2, bottom of page 2, you can see that you are copied in to the email chain by Janice Ray when sending around the list of queries from the LFB. Do you see that?
Yes.
Primarily sent to Alex Bosman and David Gibson, but you're copied into the chain.
Yes.
And I've read to you the last 2 bullet points there. Do you remember, or were you aware, that there were potentially more deficiency notices in the pipeline, in part to do with door self-closers at that stage?
I don't think I was.
Now, just looking at the 2 points, if we can go back to them, please, on page 4, the two final bullet points, or bullet questions in Rebecca Burton's email. The first question is whether the TMO is completing an in-house investigation there. Sorry, I'm so sorry. That's the pre-penultimate one. Are you completing an in-house investigation? You see that?
Yes.
Just above it. So I didn't draw that to your attention, which I should have done. The first question is, do you remember whether an in-house investigation was carried out?
I wasn't directly involved in any discussions around this. It was handled through the health and safety team and the executive team.
Right. Was any investigation ever discussed within the TMO in respect of the Adair Tower fire?
I don't know if it was an investigation. There was certainly a lot of communication, a lot of meetings happened,
Right.
but I wasn't directly involved in any of them.
Now, we then see that she asks about the systems in place to act on significant findings. That's the last bullet point. Was that something that the TMO had been struggling to grapple with?
No, I think there was a system in place.
There was a system in place. Yes. Let's have a look at your response, please. It's at page 2 in this email chain on the same day. Your response to Janice Ray when you got this email. Thanks, Janice. Can I please have sight of the FRA actions before it's issued? On the scaffold, we need to remind the brigade that they carried out an inspection of the block recently and did not pick this up as an issue. Why did you think it was necessary to make that point there?
The second point.
Yes.
Because we'd been on site, or some of my team had been on site with the fire brigade, and they'd seen the arrangements that were in place and seemed happy with them before, and then subsequent to the fire had raised them as an issue. So it was just a case of actually understanding whether they've changed their view and and why it wasn't highlighted at the time that the inspection had happened.
Were you trying to push back against any criticism from the LFB?
No, I think I was trying to make sure that there was a positive relationship between the two parties and that there was a common understanding. And obviously, it appears that arrangements that had been in place before the fire were now seen not to be sufficient or needed addressing. So it was about understanding what had changed and whether we needed to. It was basically trying to understand how we dealt with things going forward, really.
Now, by this point, the Adair fire tower had happened only a few days before. Did you realise at this point that the Adair fire was quite a serious fire,
yes,
necessitating a partial evacuation of the tower? Yes.
Yes.
Did that event prime the TMO to be very keen, not only to hear what the LFB was saying and asking, but to be able to provide them with the very best information they could? You could.
Yes, there was a lot of focus, as I say, between the health and safety team and the executive to respond to the issues that were being raised.
Right. Well, let's see how this then, in the light of that answer, let's see how this develops. Can we then go, please, to Rebecca Burton's witness statement to the inquiry, LFB 3084098. I'd like to go in that statement, please, to page 9, paragraph 16. And she says there, I met with Janice Ray on 13th November 2015, and I raised the concerns that I've outlined above. My concerns regarding the FRA's treatment of the ventilation system increased after the fire at Adair Tower on 31st of October, given that smoke had compromised both staircases through internal and external means. At that meeting, I also made some more general comments about the risk assessor. I was very frank and told her that I did not think that he was providing a good service to the KCTMO, as illustrated by the quality of the FRA for Adair Tower, which was mirrored in the FRA for its sister tower, Hazelwood Tower, which I had also reviewed following the Adair Tower fire. Enforcement notices were subsequently issued for Adair and Hazelwood Towers. Did Janice Ray inform you of her discussion with the LFB on that day as set out here in Ms. Burton's statement?
No.
She did not, right. Were you aware generally of the LFB's concerns about the TMO's fire risk assessor?
No.
So Janice Ray never raised this with you?
No, Janice wouldn't have done. Her line of communication was to Barbara Matthews.
Now, the same day, 13th November 2015, Alex Bosman emails Carl Stokes with some FRA queries. Now, I want to ask you about that. The email is at CST 402003. And it's the second email down on that page, and it's copied to Janice Ray. Now, you're not copied in on it, so we'll see how we go. The subject is FRA action queries. Hi, Carl. I've been working through completing a number of FRA actions and have identified a number of queries. Please could you review the attached and provide a response against each action? I'm keen to reduce the number of actions we receive and ensure that those that are raised are proportionate to the risk that is present on the site at the time. I understand that you may wish to highlight concerns in addition to formal FRA actions. However, it would be helpful to raise these outside of the FRA process to ensure the process is manageable and we are able to focus on and address the key concerns in a timely manner. Were you aware that Alex Bosman was making such requests of Carl Stokes?
No.
Did you?
Not specifically. I knew there was a dialogue between Alex and Janice about how we could make the process as clear and streamlined as possible.
I see. So do we take it from that you didn't direct Alex Bosman to email Mr. Stokes in these terms?
No.
Did Mr. Bosman discuss the gist of what he was going to tell Mr. Stokes in this email with you before he sent it?
I don't think so, no.
Right.
I'm not sure I understand what the issues are that he's referring to specifically.
Right. on the face of it, would you accept that this is your team, Alex Bosman, trying to interfere with the independent fire risk assessment in order to suit your own, or the TMO's own resources and limitations?
No, absolutely not.
You don't agree with that?
I think that this is part of the dialogue that I described this morning, where we were trying to make sure we had a clear, concise, streamlined process that got actions identified as quickly as possible and closed.
Yes. He says in the second paragraph, as we've seen, that he's keen to reduce the number of actions we receive and ensure that they are raised proportionate to the risk that is present on site at the time. Why was it helpful to raise those outside the FRA process?
I think what he's suggesting is, for example, when I described using the Keystone system, where so rather than generating actions for Alex's team to provide information regarding compliance and certification, giving access to the Carl Stokes to review that information himself would avoid generating time-consuming and actions that were inefficient. So that's an example of the sort of process we were trying to review. And also earlier we looked at suggesting that maybe job orders could be issued at source rather than going through a slightly convoluted process. I think they're the sort of things that we were investigating, how we could do this better.
Right. Did you and Mr. Bosman have a discussion on the subject of any need to ensure that Mr. Stokes's actions were proportionate to the risk present on site?
My assumption is that.
Well, what's your recollection?
I don't have a recollection.
Right. See, it looks from this, do you accept that Mr. Bosman, at the very least, wanted to double-check, as perhaps as a neutral way of putting it, or challenge, perhaps, Mr. Stokes's judgment about the risk level attributed to actions?
It may be that some of the actions that were allocated to Alex's team through the FRA process, in isolation, Alex might be asking for clarification as to whether that's the right priority put on them, whether they be too high or too low.
But did you actually have any discussion along those lines with Mr. Bosman with a view to reducing the number of actions?
As I've described, in terms of trying to streamline a process, yes, that was the intention. Was how do we achieve these outcomes in the most timely fashion?
Right. Did you tell Mr. Bosman to go to Carl Stokes and ask him to have a look at the risk allocations or risk levels in some of his actions and see if he could bring them down a bit?
No, I didn't. But I would have encouraged Alex to be engaging with Janice.
Right.
To ensure that the process was working effectively.
I see. Let's look at TMO 00866-493, please. I'd like to go to an email on page 3. If we go to page 3, we can see that there's an email at the foot of the page, which comes from Sasha Jevons, as you can see, to you on the 19th of November. So that's 6 days only after the email we've just been looking at from Alex Bosman to Carl Stokes. And it says, "Dear all, following our review of Carl Stokes' record of significant findings and action plan yesterday afternoon, I've reflected on what Carl said. I do not think that the recommendation to install door closers throughout the building is appropriately prioritised, currently high, for the following reasons." And then you can see A and B. A, it is not a statutory requirement to install self-closers retrospectively, therefore should not automatically default to high priority. B, I assume that the leasehold flat entrance doors are demised to the leaseholder. Daniel, can you please confirm? We do not have any enforcement power to install self-closers on these doors. The way this is currently drafted would compel us to carry out work that we don't have the power to enforce. I don't have a problem with us setting out to install door closers following the learning from the fire and completing the work promptly. However, we would be leaving ourselves exposed if we commit to completing work that we don't have the power to enforce. I suggest that the priority is reduced to low or advice, and that we make reference to the fact that we can't enforce this in leasehold properties. And then at the bottom it says Peter, and then again Peter. Now, as I've shown you, this email appears to have been sent from Sasha Jevons's email account, but it's signed Peter. Can you confirm that you drafted this email?
I think I probably did.
Yes. And then I think you forwarded it to Sasha Jevons. If we go above it on page 3, go back to page 3, you forwarded it to Sasha Jevons the next day, 20th of November, copied to Janice Ray.
Well, the email you've got here is from Sasha to me, which I don't really understand.
Well, it's difficult, I know, to understand this email chain, but what looks as if has happened is that you drafted the email, it's come back to you, or come from Sasha Jevons to you, and then you have then sent it to Sasha Jevons and Janice Ray, copied to Barbara Matthews, Robert Black, Alex Bosman, and Daniel Wood.
But it looks like something that I've drafted, yes.
At any rate, you accept that. Now, going back to page 4 in this email run, you say that you were concerned that you, i.e. the TMO, would leave yourselves exposed. What do you mean exposed there? Exposed to what?
Sorry,
This is in the penultimate paragraph, in the last sentence.
well, I think that if we are committing to carry out works that we don't have the authority to carry out, if we're committing to the fire brigade to do certain works in certain timescales, and we don't have the ability to deliver that work because we can't get access to the building, to the property rather, because actually these doors were leasehold doors, and there'd been an ongoing issue about leasehold doors renewals. So if we committed to do something that wasn't in our control, it would leave us exposed to criticism. So, because in this instance, as I remember, the leaseholders owned the doors, so we had no powers to compel them to renew those doors. And there'd been a long-standing dialogue between the TMO and the council and the fire brigade in terms of where the enforcement powers might be for this.
So exposed to what exactly? Exposed commercially? Exposed to the risk of criminal prosecution?
I think that I hadn't thought in that level of detail, but certainly to criticism if we said we would do something and then we couldn't do it.
And when you say that you would be exposed if we commit to completing work we don't have the power to enforce, enforce against whom?
So the leaseholder owns the door.
Yes.
We don't have the power to renew that door. So or to put a door closer on it. So if the leaseholder refuses or says, I've got a door of my own and I'm quite happy with it, we don't, as far as I understand, have the power to enforce them to renew it or to let us put a door closer on it. So that was a big question in terms of the door renewal programme that was run throughout the council before I arrived. And there were still some issues about how those things could be enforced. And I had understood that there was a dialogue going on between the TMO and the fire brigade about how it could be enforced.
Yes, I mean, why not just ask the leaseholders?
Absolutely.
To change their doors if they needed to, or install door closers, and tell them that it was for their own fire safety.
In some cases, people would be delighted with that. In other cases, where people had already renewed their doors, for example, or didn't want their doors or didn't want a door closer, then there was a different issue about how we would enforce that.
Right. Now, you've already, I think, you said it yesterday, that you had no expertise in fire safety.
No.
When you refer to there being no statutory requirement to install self-closing devices retrospectively, where did you get that information from?
It was my understanding that I don't remember, to be honest. I can't remember. I stood to be corrected there if that was incorrect, but I understood that the doors that were initially installed, there was no retrospective requirement to go and install door closers. In this instance, in Adair Tower, I seem to remember the doors were on, a lot of the doors were original doors which had rising butt hinges, so they were as designed in that structure, and I wasn't. I was under my understanding was that there wasn't a requirement to go and retrofit door closers.
I mean, did you seek any advice from anybody with fire safety expertise before setting out what your understanding of the statutory position was?
Well, I think the intention of this was to start a dialogue with our fire risk assessor on this point.
Well, maybe, but sorry, you're making a statement here about it not being a statutory requirement to install self-closers retrospectively. My question is, where did you get that from, that understanding?
I can't remember.
Right. Now, this email that we are looking at was sent to Janice Ray, as I've shown you. Do you remember whether Miss Ray responded to tell you that, in fact, the LFB considered that self-closers did need to be fitted to all flat entrance doors at that stage?
I don't think I was involved in that conversation going forward. I think that there was a conversation within the TMO, within the executive team, and with Janice, and probably with other members of the organisation, like Repairs Direct, because they were the people who were going to be delivering the works. I don't think I was involved in that discussion.
Right. Did Janice Ray tell you that at that stage they had concerns, worries, if you like, about what Carl Stokes was advising the TMO in this respect?
No, I've never had a conversation with Janice along those lines.
Before you sent this email, can we assume, from what you told us yesterday, that you did not look at or have any training on the LGA guide, Fire Safety and Purpose-Built Blocks of Flats, published in May 2012? No? No. Can I show you that guide, very briefly? TMO 00842279, please. I'll have the first page up because it's a document which may be familiar to others. So we know what we're looking at. There it is. If we go, please, to page 50, we can look, please, together at 62.19, which says this: it is essential that, irrespective of which option is chosen, fire-resisting flat entrance doors and doors provided to protect common corridors, lobbies and stairways should be fitted with suitable positive action self-closing devices. The self-closing device should be capable of closing the door in its frame from any angle and overcoming the resistance of any latch. Rising butt hinges used to be acceptable under previous benchmark guidance but are no longer considered suitable devices because they are unreliable in the effective closure of a door. And then 62.20, the fitting of suitable self-closing devices, whether to replace rising butt hinges pictured below or because the doors are not fitted with self-closing devices, must be undertaken in the short term as a matter of priority. Now, do you agree, looking at that your views on the priority for fitting the self-closing devices set out in your email are in direct conflict with the guidance given here in the LGA guidance?
I would say that my understanding was incorrect, but I was flagging that up as an issue to be clarified with an expert in the field, so the fire risk assessor.
Well, Mr. Millett, I do think we have to bear in mind the distinction between guidance and regulatory requirement.
Yes. That's a point for you, Mr. Chairman.
It is, but you're putting it to the witness that I can't remember exactly how he expressed himself in the email.
Statutory requirement.
Yeah. So he was purportedly at least, expressing a view about the statutory requirement,
Well, let's see.
not the requirements on guidance.
Right. Let's see how this goes. Let's go back to the precise words you used then, in light of Mr. Chairman's point to me. Can we go back to the previous email? When you said at A, it is not a statutory requirement to install self-closers retrospectively, were you seeking to draw a distinction between what the statute required as a matter of legal obligation on the one hand and the guidance on the other?
I think I was trying to highlight that we didn't have statutory powers to enforce this work, and that's really where I was coming from, and maybe I was incorrect in the way that I've put the first bullet there.
Well, let me try it this way. If you had read what I've just read to you about door closers from the LGA guidance, would you have written what you've written in A?
Irrespective of what I'd read or my understanding, I would be looking for an expert view on what we needed to do to address our obligations, and also to understand how we can practically deliver them.
Yeah.
So I wouldn't. My interpretation of what the requirements are, I would always be looking for an expert view. In this case, this was being flagged to the fire risk assessor.
Can we leave it like this, that your A there reflected a belief that wasn't, let us say, reflected in the guidance at the time that I've read to you?
To this point, I mean, the context of this conversation was that we'd had a fire risk assessment of this building. The fire brigade had visited this building, and nobody had flagged up the need to install door closers. So I was trying to understand how we'd been through this process where two experts, in my view, had looked at this and hadn't recommended we install door closers. So that was part of this, and this was me trying to set out the issues that as I saw them, because now we appear to be having a different conversation very shortly after the inspection, where we are being required to install door closers, and I was concerned about some of the practicalities of that, particularly in terms of whether we could enforce it.
Yes, that's not quite an answer to my question, but I think I understand where you're coming from with that. Going back to your email of the 19th of November 2015, at page 3, please. This is TMO 008666493, page 3. You say there that you don't think that the recommendation to install door closers throughout the building is appropriately prioritised, currently high. You were suggesting, were you not, in that the priority rating in respect of the installation of self-closing devices should be reduced from high to something lower?
Yes, I mean, high gives a 3-week timescale to carry out works, which may be quite challenging to deliver if we don't have ability to enforce work to leasehold properties.
Yes. So I think the answer to my question is you were suggesting that the priority rating for self-closing devices should be reduced from high to something lower.
And I was questioning whether that priority was correct.
Well, you're saying I don't think the recommendation is right, aren't you?
But it's not. I'm not the expert here. The expert view would be to tell me if that view is appropriate or not.
I follow. Now, you'll recall that this debate had come out of the Adair fire. Do you remember that the deficiency notice that the TMO had received after before the Adair fire, but only a few days beforehand, had said that the flat entrance doors had not been fitted with self-closing devices? And that was the problem at Adair Tower. Do you remember that?
I don't remember that specifically.
Right. Well, what difference did it make to you or your team if the priority for self-closing devices on doors were to be reduced from high to low or to advice?
My concern wasn't so much about that. It was more about having realistic timescales within which works could be done. So if it was my team, or in this case it probably wouldn't have been my team, being required to install these door closers, if you can't get access to a leasehold property to install them, then you are likely to fail. So it was about being realistic about the timescale. So it may be that if the priority is high, but it's about recognising that it may not be possible to do that work in the 3-week timescale that's being delivered, being detailed there.
Now, you said just a moment ago that you were not making a suggestion, you were simply questioning whether the priority was correct. I wonder whether that's really right, Mr. Maddison, because when we look at page 4, the way you end this email, or draft email, you say, I suggest that the priority is reduced to low or advice, and that we make reference to the fact that we can't enforce this in leasehold properties. So you were suggesting, weren't you, a change in the priority rating?
I was suggesting that that Carl Stokes could take that view on board and make a decision about whether that was appropriate or not.
You were challenging the judgment of your fire risk assessor on this matter, weren't you?
No, I was questioning. I mean, I was getting clarification as to how we could make sure that this was appropriately prioritised in a complex situation. It isn't a case of a simple situation of go and do these works. It's more complex than that, and that's what I was trying to flag up.
Well, with great respect, it doesn't really read that way, does it? Because if you were simply asking and trying to understand more, you would have expressed yourself differently. You would have said, can somebody please explain to me why Carl Stokes thinks that this is a red item, a high priority item. Instead, you're suggesting that the priority is reduced, which is why I asked my question.
But the only person who could reduce that priority would be Carl, and he wouldn't do that unless he felt that that was appropriate. So it was a suggestion.
You didn't have any fire risk assessment expertise.
No.
Whether he did or didn't is a different question. Why did you think that you were in any position to suggest that the priority is reduced to low or advice?
I think probably when I said the priority, I was talking about the timescales for delivering these works, because as I've said, I don't have a problem with carrying out those works. In result of the learning, it's about being realistic about the timescales within which they can be delivered.
Well, is that really correct, Mr. Maddison? Because if we go back to the bottom of page 3 and over to the top of page 4, you're saying, I don't think the recommendation to install door closers throughout the building is appropriately prioritised currently high for the following reasons, and you set out the reasons. So it does look very much on the face of it is that you are actually challenging the fire risk assessor's decision.
No, I think it's, as I read that, it seems very clear to me that the issue I'm flagging up is that we don't have the ability. It's the programme. The reason is that I'm assuming that the leasehold flat entrance doors are demised to the leaseholder, and we do not have the powers to enforce. That's my concern here. It's about timescales, about delivering the works. I don't have a problem with the actual works. It's being clear about whether we can deliver them in practice. That's the purpose of the email.
Right.
If I've worded it wrong in this, that's a mistake.
Why not simply suggest that the TMA go back to Carl Stokes and say, could you please rethink the timescale required for these repairs?
I think that's what I was trying to say. I think that would have been a better way of me wording it.
Well, it's not a better way of rewording the same thing. I'm bound to suggest to you it's a completely different approach. It's not the same thing as recategorising priorities. It's simply asking for an extension of time on existing items.
I'm very clear the reason I wrote this was that I was concerned about the timescales and the abilities to enforce.
Very well. It's right, isn't it? And we saw the fire safety strategy that Janice Ray had created in November 2013 earlier today, that if not classed as a red or high FRA action, then you wouldn't be required to put in interim measures. That's right, isn't it?
I wasn't aware of that specific
Right.
thing at that time.
I mean, is the reason why you wanted, on the face of it, to reduce the priority to low or advice was the need to avoid having to do urgent works or interim repairs?
No, I think that, as it's very clear in this email, I don't have a problem with us doing the works. It's about ensuring that we don't set ourselves up to fail and that we have clear process and ability to carry out the works.
If there were to be a programme of replacements or checks and installation of self-closing devices to all flat front doors, then that would fall to your team to programme and then implement, wouldn't it?
Not necessarily, no. So in this event, Repairs Direct took on the responsibility for installing the door closers.
Right.
There was so at this stage, Repairs Direct were responsible for that.
Right. If it wasn't within your area of responsibility, then why are you drafting this email at all?
I was trying to be helpful.
Trying to be helpful? Well, whose area of responsibility was it then, if not yours?
I can't remember the meeting that preceded this email, but I was obviously involved in a meeting, and had forwarded this thought because I was concerned. I mean, in a way, my team probably had more experience of delivering capital works to leasehold properties than Repairs Direct, whose works were probably more discreetly to the tenanted properties. And so I was flagging up an issue that I saw that my team had previously experienced in relation to this issue in enforcing access to leasehold properties and carry out works.
Now, let's look at Barbara Matthews' response to your email. Can we go up the pages to page 2, over to page 3? At the very foot of page 2, she responds to you, Sasha Jevons and Robert Black, copied to Alex Bosman, Daniel Wood and Janice Ray. Dear all, and then over the top of page 3, she says this: I agree with Peter's view that his finding should be low, that this finding should be low rather than high, as there is no regulation requiring the retrofit of self-closers, and we could not enforce this for leaseholders. I've asked Janice to raise this with Carl to amend the level of this finding. The action currently reads as a recommendation which we should annotate to reflect that we will initiate a programme to complete the work promptly, with the exception of leaseholders where we can only recommend that they be fitted. The Fire Brigade have requested our significant findings and action plan, and Janice has agreed with Carl that he will review this report later today and remove any actions where the work has been completed. Janice is chasing up the various teams to ensure we are able to complete some actions before we send the updated version later today. Regards, Barbara. Had you had any further discussions with Barbara Matthews before this email was sent?
I don't believe so, no.
And if we go up the email chain, you can see that at page 1, Barbara Matthews writes to Robert Black and you and Sasha Jevons on the 20th of November, Dear all, Carl has amended the significant findings to amend the item on fitting self-closers to be a strong advice item which is not coloured. I think this is a good proposal. This has no regulatory requirement or defined timescale, but is advisory only. Do you know whether Mr. Stokes undertook an independent and expert reassessment of the risk level for door closers?
I don't know.
Did Mr. Stokes explain to you, or to your knowledge anybody else at the TMO, on what basis, according to this email, he considered he was able to downgrade the risk level from red to non-coloured strong advice only?
I had no conversation with Carl.
Were you not keen to know yourself that there was a reliable and scientific basis for Mr. Stokes's downgrade?
I wasn't responsible for the management of that FRA, so that was something that was dealt with by the health and safety team, and Barbara being the manager of that team.
Or was the truth that Mr. Stokes agreed to re-rate this risk simply because you and others at the TMO asked him to do so?
I don't know. I don't know what conversation was had with Carl.
Looking at this email chain, which you got, as I've shown you, it looks very much as if Mr. Stokes did agree to re-rate this risk simply because he was asked to do so by the TMO. That's right, is it not?
I never had a conversation with him, so I can't.
No, but I'm asking you.
I can't
I'm
give an
asking you to
opinion.
accept that on the face of this email.
I recognise your opinion, but I can't say anything more.
If there was no reliable and scientific basis for the downgrade effected by Mr. Stokes, how could you be confident that you were not compromising fire safety in your buildings?
Sorry, could you ask that question
Yes.
again?
Unless there was a reliable and scientific basis for Mr. Stokes' downgrade, how could you be confident that you, as in you and the TMO, were not compromising fire safety in your buildings?
I'm sure that would be something that Carl Stokes would take into consideration, as would Barbara Matthews and our head of health and safety.
But you didn't know what that was?
I wasn't directly involved in this conversation other than giving my opinion about the practicalities of installing these works in leasehold properties in a very short period of time.
You see, isn't there a problem here? Let me spell it out to you. If you had a fire risk assessor who was prepared to do what you asked him in matters of judgment of risk, how could you trust his risk assessments at all?
That wasn't my experience. I mean, I had a limited amount of contact with Carl, but I saw a lot of work that he produced, and it all seemed very thoughtful and appropriate. And I had no reason to doubt his concern. And I'm sure that he would take on board concerns. I don't think this is about manipulating figures or actions. It's about having a conversation about the practicalities of these issues and how they're presented.
Mr. Maddison, would you accept that there's a more practical point here, namely that if Mr. Stokes thought that door closers ought to be fitted as a matter of safety, it was something that had to be considered just to keep your housing stock safe?
Yes, and I'm sure that that's what I would expect. That's what he would do, is put that with the appropriate priority. What I didn't understand, and personally from this point of view, and part of the reason I was having this conversation, was why these doors hadn't been identified to have door closers installed previously by either the fire risk assessment process or by the fire brigade at their more recent inspection. So I was trying to understand that process, but it had been agreed that we would carry out these works. It was what my concern was. It was really just about the practicalities of physically doing the works when we didn't necessarily have enforcement abilities.
All right, thank you.
Did Mr. Stokes tell you, or to your knowledge anybody else at the TMO, that he had initially made a mistake in his risk rating for self-closing doors, or otherwise explain why he was prepared to downgrade the risk category for door closers from red to a non-coloured strong advice item?
I had no conversation with Carl. He was managed by Janice Ray, and Barbara Matthews managed Janice, so that's where the conversation happened.
Did you not wonder to yourself why Mr. Stokes was so pliable?
I didn't take a view. I'm sure he wasn't pliable. I'm sure that he would have given due consideration to what was said.
Can we look again at what you said in your first statement, please, at paragraph 113? This is TMO 50892 at page 21. You say there, as stated above, in relation to the refurbishment of Grenfell Tower, I deferred all fire safety issues to the experts responsible. I had no input to strategies or equipment required and can only speak as to the contractual side of fire safety installations at the tower and my understanding of what they aimed to achieve. Now, I appreciate you're dealing with Grenfell there, and the email we were looking at earlier was more general. But is it really right to say that you deferred all fire safety issues to the experts responsible in the light of the email we've just seen?
Yes, and the email that you've just seen was referred to the expert too.
Well, you weren't deferring to the experts, I'm bound to suggest. You were making a suggestion to the experts, which was, in fact, taken on.
Making a suggestion or making a query or asking a question.
Now, in due course, it's right, do you remember that an enforcement notice was served by the LFB in respect of Adair Tower? Do you remember that?
I don't think I saw that, but I think that I understood that there was an enforcement.
Right. Well, let's, in light of that answer, let's take this quite quickly if we can. TMO 008400703. This is the notice, and it's dated the 23rd of December 2015. You see it there, and it's addressed to the TMO company secretary. And it's an enforcement notice in respect of Adair Tower, as you can see. Do I take it that you didn't see this at the time?
I don't think so.
What about later? Did you see it later?
No, I don't think so.
Can we go to page 4, please? And on that page, you can see a series of articles on the left-hand side. And under Article 9.1 and Article 10, you can see that the notice identifies insufficiency in respect, under item 2, of self-closing flat entry doors. Do you see that?
Yes.
And also under Article 10, in the second section of that, also the fitting of self-closing devices to flat entry doors there. Did anybody tell you, even if you didn't see this notice, that the absence of self-closers on flat front doors at Adair Tower was one of the bases of the enforcement notice?
I didn't see this. I wasn't really involved in the conversations around the works that emerged as a result of the notice. That was done through executive team, the health and safety team, and the repairs director, as far as I understand.
So this didn't come back to you?
No.
Right. Following receipt of that notice, then, Janice Ray, we know, had a meeting with Rebecca Burton on the 5th of January 2016. We'll quickly look at the minutes of that. TMO 00841-891. There they are. This is one of the bi-monthly meetings, 5th of January 2016. You can see who was present, Claire Williams and Janice Ray. And in the bottom of page 1, you can't see it on the screen. Can we please scroll up? Item 3, Adair Tower Enforcement Notice. Did you ever see these minutes?
No.
In particular, this section of it? No. Can we just look at the third paragraph on page 2? I'll just ask you to see whether this triggers a recollection with you. Janice sought, she says, Janice sought clarification on some of the items on the schedule. Can you see that?
Yes.
And immediately above that, it also says, Janice asked for confirmation that this notice refers exclusively to this block and that the TMO is not required to apply this to the rest of the blocks. Rebecca agreed that this does relate directly to Adair Tower. However, the LFB could expect that standards required in one block are also required in other blocks. Did you know that Janice was asking for that confirmation?
No.
Can we look at item 7 in the minutes on page 3? Flat entrance doors. Rebecca advised that the LFB requirement is for all flat entrance doors to be self-closing. Specifically, landlords must ensure that self-closing devices are fitted and also that effective procedures are introduced to ensure that these devices remain operational and are not disconnected or removed by the resident. Now, on the face of it, do you know, or do you accept that that requirement applied across the whole of the TMO housing stock?
There was a conversation that happened at the strategic health and safety meetings and with the council regarding this matter, yes.
So you understood that requirement and that it applied across the whole of the TMO's
Yes,
and stock.
and there was a discussion about how that could be delivered and maintained.
Was it your operational responsibility to ensure that all flat entrance doors had self-closing devices?
No.
It wasn't. Were you ever made aware by Janice Ray of this LFB requirement?
As I say, it was discussed.
I see, that's the discussion, right. And what did you do what did you do as a result of that discussion?
That would be on the record, but it was discussed through the health and safety operation, health and safety meeting, and with so it was discussed with the council, and there was a plan put in place to review how to address this going forward.
Right. Now, do you remember roughly when that discussion was?
I don't, but there would be records of that.
Right. Let's look later into the year, October 2016. TMO 00866-319, please. This is an email run in October 2016. And can we go, please, in that to page 4? It's an email from Ian Lines to Janice Ray on the 6th of October. Subject, Adair fire. Peter advises that following the Adair fire, the FB want us to install automatic closing devices to doors. Now, just pausing there, I'll come back to the rest of this email in a moment. Ian Lines was the head of strategic investment at the TMO.
That's right.
How did his role relate to yours at that time?
So he was the third head of the third team within my division who dealt with the strategic data management and so program planning,
right,
and stock condition information, management of Keystone, etc.
I see. He reported to you, did he?
Yes.
I see. And he goes on, is there a report available re-Adair which might help with assessing where to consider upgrading doors and closers? If possible, I'd like to gain an overview based on existing FRA actions and any likely FB enforcement anticipated. It would be good to get to the bottom of what the FB intended as their recommendation, quotes unquotes, e.g. doors in communal areas, FEDs and relevant flat lobbies depending on protection systems, etc. Peter is aiming to coordinate a report to exec which considers the enforcement, legal, technical and logistical aspects of the issue. Any help would be welcome, many thanks. And we can see the response to that at the same day at the foot of page 2, if we go there, please. She says, hi Ian, it might be helpful if we meet to discuss, but here is some of the background to this. And then she sets out on page 3, have attached a copy of the enforcement action notice for Adair Tower and highlighted the references to the requirement for all flat entrance doors to be self-closing. Our policy at the time of the Adair fire, which we had shared with the LFB, had been that when new flat doors are fitted, these would be self-closing FD30S with intumescent strips and cold smoke seals and be fully compliant with building regulations. In addition, we would retrofit self-closers to the flat entrance doors of void properties and to doors in locations where our fire risk assessor highlighted the need for these to be installed. And then she goes on. Finally, several years ago, we completed a programme of flat entrance door set, replacement of approximately 1,200 tenanted properties. These doors had been highlighted as potentially non-compliant by the FRA and then surveyed by stock condition surveyors to clarify whether they were sufficiently fire resisting. And those that were not were included in the programme. The LFB had audited Adair Tower several weeks prior to the fire there and had issued a deficiency notice which highlighted the need to ensure all flat doors in this block were self-closing. And she goes on at length. I've spoken to the LFB's fire safety team leader. Her view is that all of our flat entrance doors should be self-closing and that with our existing policy it would take too long for all of our flat doors to comply. I consulted peers at similar organisations and in general they confirmed that their policy was to ensure all flat entrance doors were self-closing. Therefore, it is likely, possible going forward, that every time one of our blocks is audited by the LFB, they will raise this as a requirement and issue a notice of safety deficiencies. And then she goes on, I'm sorry to read this at length to you, but it's important. Unfortunately, the LFB interpretation of the regulatory reform order goes further than this, and they are requiring landlords to have procedures in place whereby self-closers are inspected and those which are faulty or have been disabled or removed are replaced. Whilst the LFB state that it is up to the landlord to set the frequency and arrangements for the inspection of self-closers, they have confirmed that waiting for the property to become void would not be considered sufficient. They recently audited Lonsdale House, where the tenant's door sets were replaced in 2013 as part of the programme referred to above, and the inspecting officer has stated that he wants us to ensure all doors are self-closing. I pointed out that they had been relatively recently replaced with fully compliant door sets and that we were unable to control any resident who wished to disable their door closer, but he still sees this as our responsibility and believes this is the correct interpretation of the RRO. It is also worth pointing out that Laura Johnson at Rbkc is not keen on the idea of a borough-wide programme of fitting self-closers to all doors. However, in discussion at the recent Health and Safety Committee, there was a general consensus that we needed to be more proactive about fitting these and the possibility of including this in the cyclical DES programme, complete in 7 years, appeared to be the most effective way of proceeding. Hopefully this gives you most of the background, etc. Now, I've read that to you at length because it sets out a lot of the background. We can, just following the email chain through, if we go to page 2, you can see that on the 7th of October, Ian Lyons sends this to you. Peter, Janice's response below, compliance versus desire for borough-wide door programme. The enforcement notice for Adair is useful reading too. Once we've looked at the data, which at first glance doesn't appear to be what we need, we might be clearer. There might be information from existing FRAs which might guide us, and I'll pick this up with Janice next week. Now, just pausing there, it looks very much from that as if at this point you were sent the Adair enforcement notice that we saw dated the 23rd of December 2015 I showed you earlier.
Yeah, it looks like it was copied. Was I copied into the email above from Janice? Could I just say that?
Well, just go with where I am. Do you remember receiving and seeing the enforcement notice for Adair at this time?
But that's my question, is that if I could see if I was copied into the email from Ian Lyons to Janice.
I see.
Janice to Ian Lyons.
You're not copied into the email itself, but when you go to page 1, you send an email to Ian Lyons on the 11th of October. Ian, as details in Daniel's email attached, the councillor seeking council's opinion on this matter. Now, this email sits at the top of the string, which contains the 2 emails I've just read to you. So can I take it that you had seen both the long email I've read out at length to you and also Ian Lyons' response?
Sorry, my question was whether I was copied into to Janice's response to Ian Lyons.
Yes, I understand that. My question to you was, did you read the enforcement notice for Adair at this time, October? Once you'd become alerted?
Unclear until I know that I was copied it. I can't see.
Well, let me try it this way, Mr. Maddison. When you received Mr. Lyons' email on the 7th of October, which we know you did, partly because it was sent to you, did you ask to see the enforcement notice for Adair Tower?
Unless I've responded to him, I don't think I would have done.
Well, he says it's useful reading. Did you read it?
Not that I'm aware.
Why is that?
I'm not aware that I had a copy of it, and so
Well,
I don't remember.
Was there a problem for you getting hold of a copy of it?
I'm not sure that well, I'm sure if I'd thought that I wanted a copy of it, I don't know that I needed a copy of it. It wasn't something that I was personally dealing with. That was being dealt with by the health and safety team and the executive team who were dealing with the issues that were arising from that, and I wasn't part of that conversation.
Well, all right. You're told by Ian Lyons, who reports to you on this issue, that the enforcement notice for Adair is useful reading. do I take it from that answer you've just given me that you didn't take up his invitation?
I don't remember whether I did or not. I don't recall. It's not something that I was directly dealing with. I can't really. I mean, I'm assuming that Ian Lyons here was. It would be really useful to see the first email you showed me, because I could then understand the context of what Ian was doing.
Right.
Because I'm assuming that my assumption here is that the conversation that was being had here was that we needed to incorporate door closers into our cyclical decks program as part of so that was part of Ian's role, was looking at stock condition information, programming works and planning works. So I'm assuming that that's what he was doing, and was getting clarification from Janice as to the type of works that needed to be incorporated into that program.
Forgive me, but if you, I can't tell you from this run of documents, I can't assure you that it was attached, but if you go to the top of page 3 of the email string, you can see that Janice Ray does attach the enforcement notice for Adair Tower in her email to Ian Lyons, and he then emails this on to you. So I've assumed, perhaps wrongly, that the attachment to Janice Ray's email to Ian Lyons would also have followed Ian Lyons' email to you on the 7th of October.
But my question is, so what I'm just trying to understand is, was I copied into this email?
Well, I thought I'd shown you that. It's at page 2, yes.
Well, I think what
It's forwarded
suggesting
to you.
is it was forwarded to you.
Yes, it was forwarded.
This email, the exchange from Janice, was forwarded to me.
Well, we'll have a look, shall we, Mr.
Yes, page 2. It's been a long day, I appreciate, and we're probably coming up for a break. But on page 2, I showed you that Ian Lyons sent you the email that he had received from Janice Ray the day before. Mm-hmm. You see?
Okay, that's helpful, thank you.
Right. So, a question again. Do you remember seeing the enforcement notice at that stage?
No.
Right. Now, on page 1, let's go to that. You can see that you respond to Ian Lyons on the 11th of October 2016. And I've shown you the first line there. Going on with it, we need to give a brief to the Rbkc solicitor by tomorrow detailing the issues that we need to clarify. Some of these are detailed in my initial email, included in the attached. Have you been able to pull together what data we hold? Have you made inquiries about other authorities' approaches? What questions do we want to be included in the brief to Council? My initial thoughts on the key questions we want to Council to clarify include, do all FEDs need door closers in order to comply with the regulatory reform order / building regs, and is this retrospective? Can we enforce door closers under the terms of our leases and tenancy agreements? So it's clear from this that, first of all, you want to know what other local authorities are doing about this issue. Yes?
Yes.
And also whether you have to take action to comply with the RRO.
Yes.
And also whether you could challenge the LFB's requirements. That's what this was about, wasn't it?
No, it was about clarifying what was required.
So that you could then respond to the LFB.
No, that we could comply with what our requirements are.
Yes. But the context of this was the LFB's requirements, wasn't it, as the enforcing authority?
That was the trigger of this issue, and we were trying to explore what exactly needed to be done to comply with regulation.
Yes. All right. And let's go to TMO 008400715. The story continues. This is an email from you to Janice Ray on Friday the 14th of October 2016, copied to Barbara Matthews and Sasha Jevons. Subject, Adair Tower Fire, 31st October 15. LFB's notification to the TMO of investigation of offences. The topic is largely about what should go into the instructions to Council on the subject of inspections of self-closing devices on flat entrance doors. And you say, in the third line, at Health and Safety Committee it was suggested that door closers should be installed to all doors in the stock, Would a more precise definition be that door closers will be installed where it is identified as a fundamental part of the fire strategy for the building as defined by our fire risk assessor? This would not therefore apply to homes where the door opens directly onto the street or potentially onto open balconies with alternative means of escape. For example, the low-rise at World's End. By clarifying this point, we can start to focus on the areas of greatest risk. What lay behind that you were seeking to resist a wholesale programme of inspection of self-closers and instead trying to limit it to instances where the fire risk assessor deemed it fundamental on a building-by-building basis?
I was trying to establish what needed to be done to comply with regulation.
That's an even broader description of what you were doing, but at a slightly more granular level, Mr. Maddison. Was your purpose in doing what you've just said in order to resist a wholesale programme of inspection of self-closers and limit it instead to those cases where the fire risk assessor had said that automatic door closers were fundamental to the fire strategy for each building?
It was clarifying the point as to whether we were putting in every property irrespective or whether there were some properties where it actually wasn't necessary. And
would you agree?
Clarification.
I'm so sorry. I cut across you.
No,
to finish your answer.
I'd finish my answer.
Okay. And that would place responsibility, wouldn't it, for identifying the need for self-closers on the fire risk assessor for each building?
Potentially. I think the answer to this was that in reality in the stock there were very few buildings of that nature anyway. Most of the properties were in blocks where it was, we didn't have many houses and individual dwellings, so most of them were flatted blocks and would have required a door closer. It was just a way of trying to understand where it was essential under the regulations to put these closers in place and to ensure that we could do that in the most effective way possible.
Yeah. Did Janice Ray not tell you that of the LFB's requirement that I showed you in the minute of the 5th of January 2016 meeting, that self-closing devices needed to be fitted to all flat entrance doors and not only those identified on a building-by-building basis by the relevant fire risk assessor?
I wasn't aware of that. I don't remember being aware of that.
Right. Do you accept that your suggestion that door closers would be installed where it's identified as fundamentally part of the fire strategy for the building was inconsistent with the LFB's global requirement that door closers should be fitted and maintained throughout the stock?
Mine wasn't a suggestion. Mine was a clarification of what what we were required to do under the regulations. I don't have the technical ability or experience in fire safety to make that assessment, so I was asking for a professional opinion.
All right. Let me rephrase the question. Do you accept that your request for a clarification, if accepted, would mean that the policy or strategy would be at odds with what the LFB was after?
It was about establishing facts and agreeing a process. So I wasn't. Whatever we were going to do, we were going to need to make sure we complied with regulations and agreed an approach with the fire brigade. That was my understanding, but I wasn't managing that relationship with the fire brigade either. So I was just trying to clarify the issues that I felt that we should be getting. While we were getting legal advice on how to do this, these were some suggestions of things we should be clarifying, just so we are absolutely clear on our obligations.
And your suggestion for clarification through the legal advice was, if your clarification met the answer yes, would mean that was different from and irreconcilable with what the LFB had told Janice Ray on the 5th of January 2016.
I don't think it could be irreconcilable. I think we would have to work with the LFB to agree what we were doing. And it's about understanding the legal grounds on which we stood, because clearly it appeared, certainly it appeared to me, and it may be incorrectly, that things were changing in terms of the way that enforcement notices were being issued, and I wanted a full understanding of what the context of that was so we could anticipate that and build that into our programmes. It wasn't a case of challenging what the fire brigade was saying. It was about understanding regulation and making sure that we had something in place that prepared us for that.
Mr. Chairman, I'm afraid I keep doing this. I'm halfway through this email, but
Yes.
I'm not going to finish it before an appropriate moment for a break.
Well, then we better take one now, hadn't
It's
we?
been a long day. Yes, I'm marooned again, but yes.
All right. Mr. Maddison, we'll have our break now. We'll come back at 25 to 4, please. And the usual request, don't speak to anyone about your evidence while you're out of the room.
Okay, thank you.
Thank you very much. Right, 25 to 4. Skip. Would you ask Mr. Maddison to come back in, please? Okay.
Thank you.
No, you pour your water and get
Thank you.
organised. That's all right. All right, ready to carry on?
Yes, thank you.
Thank you. Yes, Mr.
Mr. Chairman, thank you. Mr. Maddison, thank you for coming back. Can we go back, please, to the email we were on just before the tea break, TMO 00840715. I would like to pick it up about halfway down the screen, where you say the second point. Do you see that? Do you see that? The second point is whether. Halfway down the screen on page 1 there.
No, sorry. Oh, yes. Okay, yes, sir.
Yes. The second point is whether we have the powers under the terms of the tenancy and lease to enforce the installation and maintenance of door closers. Under the terms of the tenancy agreement, we have a right to gain access to carry out essential works. I'm sure we can argue that these works fit in this category. However, what is not clear is what action could be taken in the event that a tenant removes or disables the door closer. What action is reasonably required by the landlord to check that door closers are in good repair? How can we best transfer responsibility to the tenant for this? Under the terms of the lease, it's probably less clear. I think we need to be clear regarding our ability to require door closers to be fitted and maintained. Now, is it right that your concern was whether the TMO had the legal right to enforce installation and maintenance of door closers, respectively against tenants and against leaseholders?
Yes.
Now, you ask, as we can see, a number of questions of Janice Ray, and one of which is the one I've just read out to you. How can we best transfer responsibility to the tenant for this? Why did the TMO want to transfer responsibility for that to the tenant?
It didn't want to transfer responsibility for that to the tenant. It was a question about how we can make tenants responsible for ensuring that door closers are left in good repair, i.e. not removed or repaired or reported for repair if broken. Because there is a tendency, sometimes people door closers can be inconvenient if you get locked out of your building or may be locked out repeatedly, and if doors close behind you. So people sometimes disable them because it doesn't suit their lifestyle. So what this was saying, if we were responsible for ensuring that door closers remained in working order, tenants needed to share some of that responsibility in leaving them intact and reporting them to us if they needed repair.
Right. Did you not understand that the TMO, as the responsible person under the RRO, was responsible for ensuring that the flat front doors had door closers? Which is, I think, what the LFB had said.
But this discussion here is about the practicalities of installing door closers on all properties and ensuring that they remain in place and in good repair, and how we check that, and how we ensure that our customers that agree with that and help us.
Right, you see, you talk in terms of transferring responsibility to the tenant. What did you mean by that?
So I think that the last two sentences probably should be read together, well, the last three. So because I'm saying, however, it's not clear what action could be taken in the event a tenant removes or disables the door closer.
Right. So, on whom did you think that that responsibility for ensuring that the door closers were in good repair rested?
That's with the TMO.
Mm. And if that is the case, why were you looking or asking how you could best transfer that responsibility to the tenant?
I think that's badly worded. I think it needs to be read in the context of the two bullets above, and the obligation is that the landlord is to check that door closers are in good repair. However, in the event that residents remove them or disable them, ensuring that we are clear that have the ability to enforce or take action if necessary, but also transfer responsibility to residents if the door closer breaks, for example, that they report it, so that we can repair it and keep it in good repair. Otherwise, it's very difficult to ensure that the doors of 10,000 homes all have door closers that are in good repair.
Were you aware at the time of those parts of the LGA guide, the numbers, paragraph numbers are 82.3 and 82.4, which set out what good practice was in respect of inspections?
I wasn't aware of that, no.
Right. Were you aware, and I suppose the answer will be no, that flat entrance doors which should be included in a programme of inspections to ensure that defects such as missing or ineffective self-closing devices or damaged doors or frames would be rectified? Did you know that?
No, I wasn't aware.
Right.
But the responsibility within the TMO for identifying that sort of issue would be with the health and safety team responsible for policy.
And would that answer also extend to the fact that the guide recommends 6 monthly inspection programmes, including flat entrance doors?
I wasn't aware of that.
You weren't aware of that. Did we take it from that you yourself did not understand that the TMO were responsible not only for installing self-closing devices, but also for ensuring that the flat entrance doors, including the self-closing devices, were regularly inspected and maintained?
There was there was discussion. This was the document that we're looking at here was part of a clarification process with Council's opinion about what our obligations actually were and how we could ensure that they were met. That was part of the reason for getting Council's opinion in this, and to ensure that our processes were addressing these things. We were also in dialogue with the council on this matter as well.
Right. Did you think at the time that the responsibility for installing and maintaining and inspecting flat front door closers was something that you could shift onto the tenant?
No, and that's not what I was suggesting. What I was suggesting is tenants had a part of responsibility under their tenancy to ensure that the building, that they reported repairs. So it was making sure that that tenants didn't disable self-closing devices and reported repairs as necessary. I mean, within the TMO, there was, there were different layers of inspection already going on in terms of communal areas and in terms of fire risk assessments, but there wasn't a programme specifically, as I understand it, looking at door closers.
I see. If that was how you intended the expression best transfer responsibility to the tenant, can you explain why you wanted that to be a matter for council to advise on?
I assume so, because council may have an opinion on what the terms were of the existing leases or the terms were of the existing tenancies. So there may be some legal view on whether there were requirements already within those documents that gave us powers to make sure that that door closers remained in good repair.
I mean, if it was simply a question of ensuring that all your tenants kept their door closers in good repair, you wouldn't need to ask council's opinion about that, would you?
But if one of our tenants removes the door closer, do we have the ability to reinstate it? Do we have the ability to take any action in the event that they don't want us to reinstate it, or won't report it? So I think it was about understanding the whole piece about how we could effectively manage this.
I see. Now, do you remember that on the 17th of November 2016, a deficiency notice was issued by the LFB in respect of Grenfell Tower after an LFB inspection?
I don't think I was aware of that.
Right. Well, let's look at the notice. TMO 10017254, please. This is the deficiency notice sent to Janice Ray. Premises Grenfell Tower, Lancaster West Estate. And if we look at page 5, still on page 1, you can see that the action should be taken by 18th of May. It's in bold in the first main paragraph there. Do you see that?
Yes. What's the date of the actual letter?
17th of November 2016. You should be able to see that on the screen.
Yeah.
If we go to page 5, we can see that here is the schedule of fire safety audit observations. The default property is Grenfell Tower. And then we can see in the left-hand column a list of articles which are said to be infringed. And then in the second column, issue. And then actions to be taken on the right-hand side. And you can see that under Articles 11 and 17, just on the page we've got, there is a reference to fire doors not fitting fully into their frames and fire doors protecting the escape route not closing fully in their frame. And then under Article 17.1, 17 bracket 1, halfway down, it says, during audit it was found that the responsible person for management of the access route has not prevented or addressed deficiencies in the fire resistance of the protected route. And then at the bottom, protected route has been compromised by the fitting of doors that do not self-close. Flats 44 and 153 were checked at audit and did not self-close. The same again under Article 14, second reference there on that page. And then you can see under Article 8, at the time of audit, the general fire precautions required to prevent fire and smoke spread via shafts, risers or ducting inadequate, etc. And there are others as well. I'm not going to read it all out to you. Now, you say you didn't see this at the time. Did you see this, do you remember, at any time after the 17th of November 2016?
No.
Do you remember when you first saw this notice? Or is this the first time you've...
I think this is the first time I've seen it.
Is it really? Right. Do you agree, just looking at it now, that it was plain to the TMO at the time that the LFB had taken the absence of or defects in self-closers on flat front doors as a serious issue, putting you, that is the TMO, in breach of the RRO provisions?
Yes.
Yeah. In respect of Grenfell Tower itself?
In respect to this, yes.
And do you agree that, given the deadline of the 17th of May 2017 for action to be taken, that time was of the essence?
Yes.
Yeah. And that the actions set out in the notice would fall to be addressed by your department, wouldn't they?
No.
No? Right.
So the repairs to doors and communal doors would be with Repairs Direct.
And what about the doors in the protected route?
Same.
Right. Do you remember any discussion within your reporting line, up or down, of repairs necessary within Grenfell Tower in order to put it into compliant condition at this time?
In relation to these actions, no, I don't remember.
What about maintenance of the doors? Do you remember any discussion about maintenance, either of the flat front doors or leaseholder front doors or the fire doors between the communal lobbies and the escape route?
All of those were repaired and maintained by Repairs Direct.
Right.
So I had no direct
But
responsibility.
at this time, let's be clear, to November 2016 through to May 2017, who was responsible for overseeing those repairs or maintenance programme?
The responsive repairs.
Who was responsible for ensuring that the defects identified in this deficiency notice were cured?
So I'm assuming that this letter was written to Janice Ray. I'm assuming that Janice Ray would have communicated the actions required out of this to the relevant people. I'm assuming that would have been Repairs Direct and that they would have been responsible for actioning the repairs.
Can we look at TMO 00840-763? These are minutes of the Health and Safety Committee meeting on the 19th of January 2017. We can see from the third name down that you were there. Can we go, please, to page 5, item 6.1. And this is under the heading Review of the Safety Policy and Strategy. And if we go halfway down that block of text, it's the 5th bullet point down, we can see the topic self-closers. And it says, the need to have a more proactive policy on installation of these devices in order to meet the LFB requirements was acknowledged. Suggestion that this could be included in cyclical decorations projects was discussed, but further work required on this in TMO and with Rbkc. Self-closers, regular inspection and maintenance, how and when can this be undertaken? And then there's a reference to leasehold, flat entrance doors, seek further legal advice. Do you remember that discussion?
I do remember discussing these issues, yes.
Do you remember whether there was any discussion at all at that meeting that only 2 months or so beforehand there had been a deficiency notice for Grenfell Tower received?
As I say, I wasn't aware of the deficiency notice of Grenfell Tower, but there was clearly an ongoing dialogue within the TMO and with the council regarding door closers, inspections and retrofitting.
Do you know why it had taken more than a year since the Adair Tower fire in October 2015 to acknowledge the need for a proactive self-closer installation programme or policy?
It wasn't an area of my responsibility, so I don't know.
Do you know why, at least according to this note, the TMO was only starting to consider how regular inspection and maintenance regimes could be achieved?
I don't know the timeline of what conversations were happening around this. I know that I was party to some conversations with the council about the practicalities of this, and I knew there was legal advice being sought. I don't know the timeline, and so I can't really comment on what happened between that point and this point.
So this discussion was happening around you, but not with you. Is that a fair way of looking at it?
Well, it wasn't my area of responsibility. So the responsibility was with the health and safety team, and the only aspect of this might have been if it was decided to incorporate some of these works into the programs of work that were being delivered in my team. So, for example, if it was included some of this into the external decorations program, that would be something that would be incorporated into my team. But otherwise, there would be works that would be planned and delivered through the responsive repairs or through the responsive repairs program, or the inspections could be carried out by estate services staff, for example. I don't know, but they were none of this was going to be delivered through my team, as far as I could tell, unless it was incorporated into the external decorations program. But that was a 6-year program, which may not have met the requirements here.
When it says, as we can see in the bullet point, self-closers, regular inspection and maintenance, how and when can this be undertaken? Were you not involved in that discussion?
No, because I wasn't responsible for repair and maintenance.
Were self-closers not part of the assets for which you were responsible, your contracts team?
Well, all of the buildings were part of the assets at that level, but the repair and maintenance of those assets was partly done by was exclusively done by Repairs Direct.
I don't quite understand why that is, given that they're not responsive repairs, but ensuring maintenance. Was that not part of your responsibility?
The decision had been made that Repairs Direct would deal with that.
When was that decision made in respect of self-closers specifically?
I don't know. As I say, there was a lot of conversations. The only issue that I had my eye on here was whether it needed to be incorporated into the planned maintenance programme.
Did anybody ever tell you that regular inspection and maintenance of door self-closers was not to form part of your remit?
Sorry, could you ask that question again?
Yes. Did anybody ever tell you that regular inspection and maintenance of door self-closers in high-rise blocks was not to be part of your area of responsibility, your remit?
I'm trying to understand how it seems a bit like a double negative. I'm struggling to answer the question.
Well, let me try again. Did anybody ever say to you, you are not responsible, Mr. Maddison or Peter, for regular inspection or maintenance of flat front door closers?
But nobody would say that because I wasn't responsible. So it wasn't part of the question. I mean, so the responsibility here was with the responsive repairs team.
Right. Let me try it a different way. If we want to know within whose area of responsibility the responsibility for regular inspection and maintenance of flat front door self-closers lay, what would we look at?
Maybe if I could put it another way, my areas of responsibility were strategic planning of investment and strategy. And then the delivery side of things was the capital programme, which is the largest scale capital programme, including the cyclical programme, and the mechanical and electrical engineering piece. They were the discrete areas that were my responsibility. All other repairs were carried out by the plan maintenance, by the repairs direct team. If something was going to be incorporated into one of those programmes, so for example, to run a capital investment programme to install doors, that might be something that would be delivered through that programme, but it wouldn't be routine inspections of small-scale items like door closers. That would be done through the responsive repairs team, or there was an estate services team who did inspections of communal areas. They would be the sort of the part of the organisation that would be able to take that level of responsibility. But mine was more about larger-scale programme works and responsive repairs of mechanical and electrical aspects.
Right. The topic under discussion here is regular inspection and maintenance. How and when can this be undertaken? Do I take it from your answers that that at this meeting you did not think that that was or was going to be part of a capital programme or a cyclical programme?
I suggested that we could incorporate it into a cyclical programme, but that would be a 7-year programme. It would be a longer term thing. And it could be part of the brief to ensure that as part of that works we check. But I don't think we needed something that was more reactive and targeted here to ensure that the devices were kept in repair and they were installed where they weren't already in place.
Now, if we go to the foot of page 6, please.
Sorry, can I just clarify something? I think I understand that if someone reported a door closer not working, the team to respond would be Repairs Direct.
Yes.
Who would carry out an ongoing inspection of tenants' doors to find out whether the door closers were working or not?
I don't think that had been established, and I think that was part of this conversation.
It wouldn't be Repairs Direct, would it?
It could have been.
Really?
Potentially. I mean, it's one of the options because it could have been part of, say, a regular health check in repairs. Of repairs, it could have been one of the options, or it could have been the estate services staff or the housing management staff. Even there were different ways of looking at it, and I think that was really part of the nut of the conversation here. Was actually what do we need to do? Who's best placed to do it, and what's the most practical way of managing it?
Yeah. Thank you.
Can we go down to page 6, please, and look just below halfway down? We're still under the same item within section 6 of this minute. Flat entrance doors. Specifications for replacement doors and self-closers have now been received. NFB's expectation is that the TMO install self-closers and maintain them. The committee discussed the feasibility of installing the self-closers and the risk that the TMO would be open to legally if they are not installed. Other options will need to be explored and agreed with the council. The quantity of doors requiring self-closers is not known at present. What were the options other than self-closing doors?
I don't know.
Right. Why were the TMO still at this point seeking to avoid self-closing doors? In other words, by exploring other options.
I don't think they were trying to avoid. I don't know. I don't know. I can't remember the context of that comment.
Well, you can't remember the context of other options will need to be explored. Is that what you can't recall?
Other options will need to agree with the council. I don't know what the conversation was with the council, so I don't understand the minute.
Right. It looks to the naked eye as if at this meeting, the tone of the discussion was one of resistance to the LFB's expectation that the TMO install self-closers and maintain them.
No, I don't agree with that. I think that there was an acceptance that this needed to be done. There was some concerns about the practicalities and how it was going to be delivered.
If there was an acceptance of that would needed to be done, why was there a discussion of other options needing to be explored and agreed with the council?
I don't know what those options were that needed to be explored.
Why was this matter even being debated at this meeting? My question is, why weren't you just discussing getting on and curing the deficiencies by the deadline and getting the working door closers actually fitted and operating?
This wasn't my agenda. This was Barbara Matthews' meeting. She used the forum to raise awareness of health and safety issues across the organisation. So there was the attendance here wasn't just senior managers. It was up and down the organisation. It was trying to raise awareness of the importance of these issues and how everybody had a responsibility for ensuring health and safety within the organisation.
And if this was nothing to do with you, because it didn't fall within your area of responsibility, can you explain why you had got involved in the November of the previous year in discussions about what instructions to send to council on the question of door closers?
I can't remember.
Right. Now, there's a joint management team meeting on the 1st of March 2017 with the Rbkc executives, which you attended, and we'll look at the minutes of those. Those are at RBK 00014072, please. And I say the RBK executives, it's a joint management meeting, and there are some executives there. You can see who's there from Rbkc, Laura Johnson, Amanda Johnson, etc. And from TMO, we can see that you were there, as well as Robert Black and Barbara Matthews. If we go to page 2, please, we can see that the door closer issue is dealt with at item 5 there, at the foot of the page. Installation of self-closing doors and annual inspection. Will be a huge cost if want to do this. Nobody has an inspection process at present, as it's not a legal requirement to have yearly checks. Could be an option to include in the fire strategy. Need to develop a programme and take to scrutiny. Liability if the doors are broken would be with the TMO. Laura agreed to hold off recommending inspections programme at present. Why was it a question of wanting to do this? As you can see in the first line, will be a huge cost if wants to do this. You'd been told by the LFB some time before this that it had to be done, no?
I hadn't been part of this conversation. I was involved at the very outset of the conversation, and this whole dialogue has been taken over here by the executive team, and I had very limited involvement in this, so I can't really shed any light on this, I'm afraid.
And when you say you weren't involved in this conversation, hadn't been part of this conversation, does it mean you weren't? Do you mean you weren't at that part of the meeting?
I was at this meeting, but all of the exploration of the issues around door closers and how they were going to be delivered was being dealt with outside of. I wasn't involved in that discussion, so.
Well, let me see if I can recreate the scene. You were at this meeting from beginning to end, were you?
Yes.
Right. When this topic, as item 5, came up, who led the discussion from the TMO's side?
I'm assuming it was Barbara Matthews.
Do you remember that, or
I don't really remember the meeting, to be honest, but I'm assuming it would have been Barbara, because she had her responsibilities under the as executive director for health and safety, but she was also jointly managing the repairs director.
Was there a reluctance by TMO or Rbkc to carry out installations or inspections because of the huge cost that would be incurred?
I don't think it was about. I wouldn't have thought cost would have been an issue. I think there were probably concerns about the practicality of how we could achieve this.
Well, somebody certainly seems to have said at the meeting, will be a huge cost if we want to do this. Can you explain the context?
As I say, I didn't have any detailed understanding of this conversation. I was party to it, not part of it.
Right. Are you able to explain what liability if the doors are broken would be with the TMO meant?
No.
On the face of it, it looks, to the naked eye, the untutored, those who weren't at the meeting, that what TMO and Rbkc were doing here were prioritising cost and liability exposure over safety.
I don't think so. I think they were considering practicalities.
Right. Would it have been your department that would have carried out this global installation programme?
No.
I ask you that because it would have been a major capital programme, wouldn't it?
I think it was the sort of work that Repairs Direct were very keen to take on. So it was rather than being a reactive repair, something you could plan for and deliver in larger volume. It was very much along the lines of where the Repairs Direct organisation was looking to develop. Right. So it felt like it was a project that they were going to take forward.
If you go back to page 1, you can see who was there. Was anybody from Repairs Direct there?
No, nobody from Repairs Direct would attend any of these meetings.
No. Was anybody there, or who was there, who to whom Repairs Direct reported?
Barbara Matthews.
Right. So when you say that this was something that Repairs Direct was very much looking to develop, did Barbara Matthews actually say that?
I don't know.
Right. There's no hint in this note that a programme to be taken to scrutiny would fall outside the capital regeneration and investment remit that you had.
My understanding was that this was going to be delivered through Repairs Direct.
Who gave you that understanding?
From any of the discussions that we'd had through this process.
Can you just help with this? Had any attempt been made by the time of this meeting, this is March 2017, to assess the number of doors which would require new or even replacement self-closing devices?
Well, certainly that's where Ian Lyons' dialogue initially was. He was working with Janice Ray, so Ian Lyons would have had access into our stock condition database, so would have been able to try and access whatever information was available in there. Although I suspect that wouldn't have gone down to the granular detail of door closers. It would have probably stopped at a door, and it may have been able to tell you whether it was a self-closing door or not. But so that was probably where Ian Lyons' involvement was. But from that point forward, all of the planning of this was being done through Repairs Direct, and I'd had no direct involvement in it.
Now, I asked the question because we see, I think, no reference in these minutes to to give us any indication of the size of the undertaking. Now, we know that there were self-closers fitted to doors in Grenfell Tower, although in some cases they were broken or missing. Mm-hmm. We know that there were no self-closers, I think, fitted in Adair Tower. There were a lot of other properties. Had no one taken any steps by this time to assess the size of the problem?
I think there was a mixed picture. I think that certainly in Adair, some of the where doors had been replaced, they'd been replaced with doors with self-closing devices, but where they were original doors, they wouldn't have been. So I think that was part. This was a mix, and I think that before my time at the TMO, there'd been a program of fire door installations, which my crude understanding was that all doors were fire doors that had been recently fitted and installed, other than a few outliers that the health and safety team were aware of. However, what we didn't have an accurate record of was were the instances where door closers may have broken or may have been removed, and so the inspection process was going to have to be an ongoing process basically from the beginning, and starting from scratch, I think. And it was trying to find the vehicle to do that and assess the process.
Right. Yes, thank you. Yes, Mr. Willett.
Yes. Could we please now look at the minutes of the TMO Health and Safety Committee meeting from the 16th of March 2017 at TMO 1001671. And if you look, please, at page 4, we can look at sections 3.3 and 3.4, feedback from LFB. An audit was carried out by LFB on Whitchurch House sheltered scheme in February. At the time of the previous LFB audit in March 2016, the block had been confirmed as broadly compliant. The same FRA remains in place, and there have been no material alterations or other significant changes which would impact on fire safety. However, on this occasion, the LFB have issued a deficiency notice with many issues. JW confirmed that in consultation with Carl Stokes, HC and JJ, she had drafted a response setting out the TMO's position or policy in relation to each point raised, and this had been sent to the inspecting officer and fire safety team leader. A response is awaited. And then you say, or it records you suggesting that it may be possible to strengthen TMO's position by using an independent fire safety expert to review challenges from the LFB, JW to investigate, and that's a JW action point. Why did you make that suggestion?
I think what appeared to be happening is that there had been a couple of serious incidents that in relation to the Adair fire, and the approach from the fire brigade seemed to have changed, and I thought that it was important that we understood the position really clearly from a professional perspective, so that we could plan our programs effectively. So it was all about trying to get ahead of things rather than being reactive. So it felt at the moment that the fire brigade were issuing notices and we were being reactive to that, whereas I felt that we needed to be more proactive, and we should get some professional advice to help us understand if the position had changed.
Well, with respect, it's not quite what it says. I mean, tell me if this is an inaccurate minute, by all means, but what you're, on the face of it, suggesting here is using an independent fire safety expert to review challenges from the LFB, not to give you better fire safety advice so that you could get ahead. That's right, isn't it?
I think it's poorly minuted, but I think when reviewing challenges, I mean, I guess these minutes were taken by Janice, and maybe that's how Janice saw them, but it was about reviewing the actions that were coming from the deficiency notices and understanding how we could best proactively respond to those issues.
Well, again, you say it's poorly minuted, but I don't think we've got any record of you ever going back to Janice Ray and saying, that's not what I said, or that's not what I suggested.
I think the broad action of investigating, bringing in an expert view, I would stand by. I think it seems like a sensible approach, and the semantics around whether that's reviewing challenges or reviewing actions just from deficiencies, I think is a bit of a moot point.
Well, I agree with that, so far as my agreement is relevant. My point is that you were suggesting bringing in an independent fire safety expert in order to look at what the LFB were asking you to do and see if you really needed to do them?
There'd been a series of. I was recognising there'd been a shift here in the way that the fire brigade were approaching, or it appeared to be, from what I could see in terms of the number of deficiency notices that were being issued and the way that they were being, and some things that had been previously compliant were then being identified as non-compliant. So there's clearly a shift. So what I was suggesting was we get somebody, a specialist in to help look at what we're doing and ensure that it met with regulations and that we knew we were being proactive in doing that.
Why not simply accept the challenges from the LFB and take them at face value? What was wrong with that as an approach?
I think we did, but I think this was about looking forwards. If this is an ongoing thing, are there other issues that we ought to be considering? Because if we're getting a series of deficiency notices, it implies that something's wrong. So why wouldn't we get some expert review as to what we're doing and whether we need to correct it?
But you say if we're getting a series of deficiency notices, it implies something is wrong. Do you mean something is wrong with the LFB or something's wrong with the TMO?
I don't know. That's why I would want a fire expert to come and tell us, to review what the situation is and ensure what action we would need to take to ensure that we were doing the best we possibly could.
I mean, the reality is, isn't it, looking at this, is that you were suggesting retaining an independent fire safety expert in order to strengthen the TMO's defensive position against the LFB.
Well, that's not my role or my position. What I was trying to do is to anticipate the sort of investment levels, the standards that we needed to be achieved to make sure that they were reflected in the standards that were being delivered in the works that my team delivered, and we could plan that into our investment programmes going forward.
Right. Let's look at the item, next one down. It starts at the very foot of the page, review of fire safety, item 4, and goes over the page to 4.1, the top of page 5. And it says this: with regard to an installation programme for self-closers, JW confirmed that since Cynthia Vacchino, Rbkc Legal Services, had been asked to review the access procedure used to facilitate the fire safety works required by the enforcement notices at Adair and Hazelwood Towers. It was suggested that this be referenced to in the reviewed fire strategy. BM advised that Rbkc had been consulted and had confirmed that their view that we adopt a 5-year installation programme for self-closers, but that at this stage we should not investigate an inspection programme. And then PM suggested that any clarification from Council or Rbkc Legal be incorporated into the fire strategy to formalise the TMO's position on where self-closers would be fitted and which doors would be inspected. Why were you making that suggestion if this topic was outside your remit?
So these are health and safety. Well, I'm part of a health and safety committee. It's part of a corporate responsibility, and I was making a suggestion. I don't know why. I was trying to be helpful.
Right. Right. In light of the LFB's stance on the need for self-closing devices on all flat front entrance doors, as we've seen, do you know why Rbkc had decided not to implement an inspection programme?
I don't.
To your knowledge, did Rbkc know of LFB's stance on the need for self-closing devices throughout the borough?
I don't know.
Do you know whether Rbkc had taken account of that stance at all when making decisions?
I don't know.
Did anybody, to your knowledge, at the TMO question the wisdom of Rbkc's decision?
I don't know.
Why did you suggest recording the advice of Council or Rbkc Legal in the TMO's fire safety strategy?
So we were clear on what the position was. There was a clear policy decision so we could make sure that that was addressed.
Was it in order to be able to show it to the LFB?
Well, I don't think the LFB would be interested in our policy, really. I think they'd be interested in what they felt they could enforce. So
Right. Were you concerned that the decision not to inspect might be challenged by the LFB?
I didn't have a view.
Or challenged by somebody else?
I didn't have a view.
Do you know if any such clarification about access was in fact recorded in the fire safety strategy?
I don't.
Do you know what the upshot of this suggestion was?
No.
Moving on a month, you were forwarded an email by Janice Ray on the 19th of April 2017. And the best way I think of dealing with this is in your second witness statement, please. If we can go to that at paragraph 52 on page 11. And you say in paragraph 52, I have also been asked whether I had any knowledge of fire risks arising out of the use of cladding or cladding systems. I recall that the findings of the Lacknell House Inquiry were referred to and considered by the TMO, as were the findings made in relation to the fire at Shepherd's Court. In relation to the Shepherd's Court fire, I recall being forwarded by Janice Ray a copy of the letter from the LFB entitled Tall Buildings External Fire Spread in April 2017. I recall discussing the contents of this letter with Janice Ray. However, my recollection is that the letter was referring to the risk associated with non-compliant cladding, and I understood the cladding of Grenfell Tower to be fully compliant with building regulations, as building control issued a certificate of completion. Could we look, please, at TMO 00861973? This is, well, can we go to page 4, in fact, to start with? Page 4, which is an email from Laura Johnson to Robert Black on the 19th of April, which encloses, under an FYI, at the very bottom of page 4, a letter from Hannah Loffer, or Lua, I'm not sure how it's pronounced, to Laura Johnson on the 6th of April, 2 weeks before. Subject, letter from LFB, external fire spread. And the email reads, Dear Mrs. Johnson, for your information, please find attached a letter regarding our advice relating to the issue of external fire spread. And we can see, if you go up the chain on page 4, through 4 to page 3, Janice Ray sends this on the 19th of April to you, as well as others, including Alex Bosman, Graham Webb, etc., etc. Copy to Barbara Matthews. And if we go to page 2 of this email chain at the bottom, we can see that Barbara Matthews responds to Janice Ray and asks whether, she asks this question, do you know which of our buildings has the type of infill panels, etc., that are referred to in the letter? I also assume the cladding recently installed at Grenfell would be compliant. My question to you, do you know why Grenfell Tower was specifically singled out for mention by Barbara Matthews?
It was a very high-profile project,
right,
and it was the only building that we'd overclad.
Right. If we go to page 1, please, and over the foot there of the page over to page 2, we can see Janice Ray's response. She says, this is the top of page 2, Hi Barbara, to the best of my knowledge we do not have this type of cladding on any of our buildings, but we'll discuss again with A&R. Carl has asked a lot of questions about the Grenfell cladding and is happy that the material and the fixings are compliant, but have copied this document to him as well. Regards, Janice. Now, do you remember looking at the letter that had come to Laura Johnson from Hannah Lauer on the 6th of April?
I do.
You do. We can look at it. It's a lengthy letter, and I'm not going to read it all to you. Rbkc 3026888. It's dated 6th of April. The title is Tall Buildings External Fire Spread. And it's a lengthy letter. Did you read it at the time?
Yes.
You did. I'm not going to read it all out to you. Can I ask you just to look at the 3rd and 4th paragraphs on page 1? We've seen a number of cases where it appears on the basis of the information available to us that the level of fire protection to the external face of the building did not comply with the requirements of Part B of the building regulations, insofar as they seek to limit the speed at which a fire can travel and spread over the external face of a building or may contribute to a fire. Testing of panels has found that the combustibility of the composition of the panels at Shepherd's Court did not meet the levels expected for conformity with the building regulations. On testing, it was found that panels may deform or delaminate, exposing any combustible core or constituent material, resulting in the panel becoming involved in the fire and allowing the fire to spread and enter flats other than the flat of origin of the fire. Then if we turn to the next page, please, you can see that the last paragraph says this: I would therefore strongly urge that you consider this issue as part of the risk assessment process for premises under your control. I suggest that you make sure all relevant information about any replacement window and facade schemes is fully available to fire risk assessors. Where no reliable information is available for a given property, it is our general expectation that a strategy to assess the risk and, where necessary, implement short, medium and long-term actions to address the risk. This assessment will need to take account of other fire safety measures already in place in the building, as well as potential mitigation measures to ensure that any potential fire spread does not pose a risk to health and safety. Did you look into the issue of whether the cladding on Grenfell Tower may have presented a fire risk at this stage?
I discussed this with Janice Ray, and she agreed to speak to Carl Stokes and get his opinion. I mean, the way that this letter was phrased was very much about there are some of these works which may not meet building regs,
right.
And we had a project at Grenfell Tower that was still within defects at this time and had a building reg sign-off. So there's an assumption that it did meet building regs, but we did get Carl Stokes to take a look at this in the context of Grenfell, and he obviously gave his comments back to Janice.
So Janice checked with Carl Stokes, but you didn't, is that right?
That's right.
Right. Did anybody think of asking Mr. Stokes specifically to confirm that the cladding at Grenfell Tower was safe as part of his fire risk assessment?
I don't know what conversation Janice had specifically with Carl.
Did you raise this question with Claire Williams and ask her whether she could help with the specific response in relation to the Grenfell cladding?
I don't remember if I did, but it may be that Janice Ray did. I can't remember.
Did you check or ask to be checked the ex-over fire safety strategies or reports to see what they said about the cladding?
Not in the context of this. I followed the advice and got the fire risk assessor to consider this.
Did you contribute to a response back to Laura Johnson?
No,
Was that ever done, as far as you're aware?
I don't know.
Right. Do you know whether Robert Black sent Laura Johnson a message?
I don't.
You don't know. Mr. Chairman, it's 4:30,
Yes.
And I am pretty much at the end of this line. It's not an inconvenient moment, but I do regret to say that I am not finished with my questions for Mr. Maddison, and I'm going to have to invite him to come back on Tuesday. I regret the inconvenience to you and to everybody else, but I'm afraid there is still some material yet to cover.
For Mr. Maddison's benefit, if not for everyone else's, can you give an idea of how long you might need with him?
Yes, I would think that it would. I would take until lunchtime on Tuesday. Now that there is a knock-on effect with the next witness after that, who is an expert.
Yes.
Sir Jonathan Sakula.
Well,
but I don't think that causes any difficulty with him, although it may be that we have to address precisely it is when we start with him. But I'm thinking of this witness.
oh yes, I just wanted an indication of
Yes.
how much more time you thought you might need. All right, well, that's helpful. Thank you very much. Mr. Maddison, I'm sorry, we were hoping that we would manage to complete our questions today, but I'm afraid it hasn't been possible. So I'm going to have to ask you to come back on Tuesday.
Okay.
It sounds to me as though you could reasonably hope to get away by lunchtime, but I wouldn't put it higher than that, I'm afraid. There's going to be quite an interval between leaving here this afternoon and coming back on Tuesday. So please, I must ask you not to speak to anyone about your evidence or anything relating to it over the long weekend.
Okay.
All right?
Thank
you
you.
very much. Well, we'll see you on Tuesday morning at 10 o'clock.
Thank you.
If you'd like to go with the usher now. Thank you. Right, Mr. Millett. Well, that's it for today. We shall not be sitting on Monday. It's a bank holiday, and so it's 10 o'clock on Tuesday.
Very good, Mr. Chairman. Thank you very much.
Thank you very much.
Thank you.